Thank you. I want to tell you, this is an incredibly rare opportunity to have heard a gentleman of this stature in this position in American life and culture come speak on a subject area outside of what he does as a judge is quite amazing. So these are coming in. I've got to take these off to be able to read them. And let's see. How is the recent Supreme Court ruling on, okay, he's got to be careful how he answers some of these questions. There are rules. Well, you're a big boy. How's the recent Supreme Court ruling on DOMA going to impact the church vis-a-vis mandatory performance of weddings?
Oh, technically that ruling has nothing to do with the issue of whether the states or the churches have to honor single-sex marriages. It has nothing to do with that. It just deals with when federal statutes refer to marriage, what does that refer to? DOMA simply said that in federal statute it refers only to marriage between a man and a woman. And DOMA said no, that's wrong. It now refers to whatever unions were lawful under the state that concluded them. It has nothing to do with whether the states must recognize same-sex marriage, although, as I said in my dissent in the case, that's the shoe that will next drop. I mean, I think it's coming, but DOMA doesn't do it.
Have you ever noticed that positions of justices on a particular subject change or become more liberal the longer they're on the bench? I will say for this justice who's been on the bench
here
the
a long
longest,
time.
I've never
Are you? It's demonstrably false. I've been there longer than anybody, and I don't think I'm any further left than I was. Well, no, but it is a common phenomenon that when one arrives at the Supreme Court, one tends to think that the court ought to decide more of the crucial issues for society and not depend so much on the text of an old constitution. It's natural enough, I suppose, but and I think it is certainly a true phenomenon. John Paul Stevens, for example, was quite a what should I say, non-activist judge when he was on the Seventh Circuit, and did not turn out that way on the Supreme Court.
We have so many phenomenal questions. I'm limiting these to ones that I'm interested in. I'm sorry about that. He's got no warning, okay? So this is like not fair to him. Of all the opinions you've written, do any come to mind that you're particularly proud of? Or that are your favorites?
Well, my favorite dissent is probably one pretty early on. I was the sole dissenter in the case deciding whether the independent counsel was constitutional. I said that he wasn't, she wasn't, Alicia Morrison. 7 justices thought the opposite. A few years later, the court did a 180-degree turn on the crucial issue in that case, whether an independent counsel is an inferior officer or not. You don't have to know why that's important. So I think I was sort of vindicated. I wrote that later opinion, by the way, but the author of Morrison versus Olson joined it. Don't ask me how. Bang, For majority opinions, I guess there are 2 I'm proud of. One is the Heller opinion, which was Second Amendment, the first opinion of the Supreme Court that really decided whether the Second Amendment conferred a private right to keep and bear arms. And also a case whose name I always forget, that restored the Confrontation Clause to its original meaning. It Well, I'll talk about that because it says something about it. Some people think that when you depart from the original meaning of the Constitution, you're always creating greater freedom, you know, there's no harm done. That's not true. I mean, if you ignore the original meaning of the Constitution, sometimes you'll create more freedom, sometimes you'll eliminate prior ones. And what we had done with the Confrontation Clause, which guarantees in all criminal prosecutions that the accused shall enjoy the right to confront the witnesses against him. No doubt what that meant. It meant you had to bring the witnesses into court. You could not use hearsay. You could not bring somebody, come in and say, well, I wasn't there, but Joe was there and he told me. No, you can't do it. You have to have the opportunity to cross-examine the person who's sending you to prison. About, 25 years ago, we just kicked that aside and said in a case called United States versus Roberts, that all the Confrontation Clause means is that any hearsay you introduce has to be reliable hearsay. Okay. Well, I wrote the opinion that overruled that, maybe about 8 years ago or so. And so the Confrontation Clause now has the meaning it had at the beginning. I'm very proud of that opinion.
You are so persuasive and logical. Why aren't you able to persuade your liberal colleagues?
Look, on most of these issues on which we disagree, it's fundamental stuff. I mean, it's about whether you think the Constitution bears its original meaning or you think it changes. Well, my colleagues have thought about this for years. I'm not going to change their mind on those fundamental questions. If they think it's a morphing Constitution, that it means whatever they think it ought to mean today, they're not going to change that. They're going to say, "What? My God, Nino, yes, originalism. Why didn't I think of that before?" We don't even talk about fundamental stuff like that. Don't even talk about it. These guys have had their philosophy for, 30 years at least. I'm not about to change their basic philosophy. Now, on most of the real law cases, most of what we do, believe it or not, sometimes people come and say, "Well, Justice Scalia, why do you have to be a lawyer to be on the Supreme Court?" The Constitution doesn't say so, and it doesn't. Because they think most of the time, we're contemplating our navel. Should there be a right to die? Should there be a right to abortion? Something that Joe Sixpack knows the answer to as well as I do. It has nothing to do with anything you learned at Harvard Law School, nothing whatever. But in fact, most of the time, we are not doing that garbage. Most of the time, we are doing real law. We're figuring out the meaning of the bankruptcy code, the Internal Revenue Code. That is hard and really dull stuff. And only a lawyer can understand it. So, if people understood that, they would never ask that question. Of course you have.
Do you have a favorite opera?
Oh, that's a very, no, I can't say have a single favorite opera. I like a lot of different operas.
Do you still sing in your church choir?
I don't. When I was a professor, I sang in a chorus as late as when I was on the Court of Appeals, before I got appointed to the Supreme Court. It's called the Wareham Chorale. We sang at the National Cathedral, at the Smithsonian, other places. And I miss it. When I was a professor at the University of Chicago, my next door neighbor was the director of the Rockefeller Chapel Choir. Those of you who know the University of Chicago, Rockefeller Chapel is a cathedral. I mean, it's around, 20 times the size of your little church here. And it had an endowed choir. Sometimes there were more people in the choir than there were in the congregation, to tell you the truth. But it was a wonderful choir, and I would go there Sunday morning and sing Palestrina, William Byrd, Mozart, this magnificent choral religious music from 1,500 years. After which, I would go down the street to Mass and hear some clown strum a guitar and sing "God is Love, Kumbaya" or something like that. It used to rip me up. Anyway.
While you're on the subject, would you please evaluate the condition of the Catholic Church in the U.S.?
Evaluate the condition? Well, it's doing okay. It's been around a long time, you know.
All right, I've got about 4 more that I'll run out here. 2 serious, 2 less so. Less serious. Are you a Redskins fan?
No, I'm not even much of a football fan. To the extent I am, I hate the Redskins. In fact, I always root for Dallas.
How, and this may be something you don't want to answer. How would you handle Syria?
No, I shouldn't talk about
Okay. Now here's the educational
I have
question.
strong views on it.
Fair enough. Here is a legal education question.
All right.
What is the constitutional basis for the principle of stare decisis? Does it play inherently to the socialists?
Well, the constitutional basis for it is that it is impossible to run a judicial system without it. I mean, you can't reinvent the wheel with every case. I mean, a lawyer gets up and says, Your Honor, this statute is unconstitutional because, wait, counsel. You say this statute enacted by Congress is unconstitutional? Do you think we have the authority to declare a statute enacted by Congress unconstitutional? Marbury versus Madison, Your Honor, 1830. I know, but was it right? Yeah, you're going to go into that all over again? You cannot possibly revisit every legal holding of past courts. And that's the basis for it. The Constitution implicitly expects the courts to function in a manner that is not nuts, okay? That's a very technical explanation, of course.
But it leads very well to our last question. What stands out in your mind as one of the greatest miscarriages of constitutional justice you've seen during your tenure?
Whoa. What's the worst? I've never been asked that question. What is the worst?
This may be a winner.
So many candidates. I can tell you an area in particular, the area of law. I wrote this before I became a judge even. I said that the most disreputable area of our law is the Establishment Clause, and it has remained that. Our opinions just in that field make no sense. They still don't make any sense, and we don't seem to be able to bring any coherence out of them.
For the non-lawyers in the group, the Establishment Clause?
Congress shall make no law respecting an establishment of religion. It's the clause that's always invoked when people want to tear down a cross that's been put up on public land, or remove a creche that's in the city square or whatever, or take down the 10 Commandments, so forth. There are two religion clauses. One is that. The other one is the free exercise clause. And there's no doubt that when your free exercise has been affected, you should have standing to complain. But a violation of the Establishment Clause that does not affect your free exercise, there is no reason why you should have standing, any more than you should have standing to complain about the federal government acting in areas where it has no constitutional authority to act. Unless it hurts you, you don't have standing. But we have made one enormous exception to that, which is the Establishment Clause. And that's how we get into all these, I think, silly cases. I mean, why did we not have these cases until the middle of the 20th century? We didn't have cases about it. Was because, until then, we didn't give standing for. Anyway, that's the area that is really the worst.
Great answer. You have had a privilege and an honor to hear his honor tonight, and would you thank him with applause?
Thank you. Thank you.
God bless you all.